My name's Ashley. I'm one of the senior consultants here at EmploySure. So at EmploySure, we understand that employers regularly face challenges in interpreting the New Zealand employment and health and safety legislation. We know that workplace relations are really dynamic and can be really complex. So this webinar is going to clarify and outline 5 areas that we feel are essential to managing your business. And with that in mind, the topics that we're going to go through are annual holidays and parental leave obligations, workplace disputes and common areas that we see arise, discrimination, employee performance and then termination, and then health and safety at work. And like Jason said, feel free to ask questions along the way using that chat area, and then what I'll do is come to them at the end and then just ensure that everything has been addressed. Perfect. So in regards to annual leave, so this is outlined in the Holidays Act, and all employees are entitled to this as a minimum. Basically, a permanent employee gets 4 weeks paid annual leave per year, and this is after they become entitled to this after their first anniversary of employment. So this is after 12 years of service, 12 months, sorry, of service. There are some special examples where annual leave may not be as simple as 4 weeks paid per year, and what that is around, say, Christmas. You can obviously do a close down period, and that is where you prescribe that an employee must take their annual leave at this particular time, typically when the business suspends their operations or that sort of thing. You may also pay out, give an employee 1 week of unpaid leave in the year, and that would then make an anniversary date determined by the employer. So if someone does take unpaid leave, an employer may then move that employee's anniversary date, which means they would not accrue annual leave over that unpaid time. Annual leave accrual does accrue on a pro rata basis. So for example, if someone works 3 days a week, they still get that 4-week entitlement. However, a working week for them would not be 5 days. They would just get 3 days for that particular week. So therefore, they get a total of 12 days annual leave per year. The legislation, however, does refer to annual leave on a weekly basis, not a daily basis. So where annual leave becomes nice and complicated is with your casual employees. So you're going to go through a few scenarios there just to sort of see what your obligations for casual employees would be. So if you have a casual employee that works on an irregular kind of basis, so that's your genuine casual, irregular, intermittent work, they typically get the annual leave as a pay-as-you-go basis. So that would be 8% on top of their normal wage, and it's just paid along with their weekly salary. If you are going to do this, this must be agreed to in the employment agreement. So both parties do need to agree, and this does need to be in writing. If you have a casual employee who is developing a work pattern, and I would usually look at kind of a 6-month period, is this person working regularly, even if it's only 1 day a week? To me, that doesn't sound like a true casual employee, and because of that, I would say that they should be issued with a permanent employment agreement, and therefore they would then just accrue annual leave like normal permanent employees. In regards to casual employees being entitled to sick and bereavement leave, so this is always, again, a tricky one, but basically if they fulfill the following criteria, they are. So they must have worked for 6 months, and they must have worked an average of 10 hours each week, or at least 1 hour a week over 40 hours a month. So it can get pretty complex to figure out. So I would say definitely use a payroll system, and they'll be able to manage that for you. If a casual employee is sick or does suffer a bereavement, what you would sort of look at as to whether they would get that day paid is would they have otherwise expected to have worked that day. So this comes up quite commonly when you see casual employees on a roster, or you might have a casual employee who you called in the week before or something like that, and then for whatever reason they were unable to attend because of sickness or a bereavement, and they then meet that criteria, they may get that day paid. Obviously, if you have that kind of casual relationship where you're just calling people on that, as work becomes available, if they weren't going to work and they indicate they're sick, you wouldn't pay that sick or bereavement day. So now going on to handling a request for more than 1 week of unpaid leave. This is pretty complex, and the Holidays Act unfortunately isn't particularly clear, but what basically someone who does apply for 1 week or longer of unpaid leave, like I briefly mentioned before, you can push out the anniversary date for the next entitlement of their annual leave. And what this basically does is it just means they don't accrue leave during that unpaid time off. If someone was only going to take 1 or 2 weeks, it's a lot of admin for not a lot of benefit, but this would be something you might look at doing if someone was taking sort of a month or more off unpaid, and you had agreed to that unpaid leave and were happy for that to happen. And then what happens is when they came back, their annual leave accrual would then begin again, and they would then be entitled to that week after the next 12-month period. So the leave obligations at the end of employment. So holiday pay, they do get it's calculated again each time employee goes on holiday, and they get basically the higher of their average weekly earnings or their ordinary rate of pay. Basically, it means that the employee is always in a better off position if they had, for example, just got a pay rise. What you would then get, is that leave with that pay rise in mind. Whereas if the employee, for example, worked, on a commission basis or did quite a lot of, overtime or that sort of thing, that would also be factored in then by dividing the figure by 2 to get your average. So basically, what each time you would do is figure out what's higher, average weekly earnings or ordinary weekly pay, and that's what the employee would be paid when they took annual leave. Great to see heaps of questions coming through as well. Thanks, guys. And now, end of employment with annual leave. So if the employee hasn't worked for 12 months, they technically have not been become entitled to annual leave yet. So that annual leave payment is just made at 8% of their gross earnings over that 12-month period, less any leave they had already taken. If annual leave has become entitled and an employee resigns, that unused annual leave is paid out at that previous method I just mentioned, the ordinary weekly pay or your average weekly earnings. So again, it will be paid out at a higher rate if that's applicable. If again they have some accrued leave, that's then paid at your 8%. But again, I can't enforce enough. Payroll systems are worth their weight in gold because it figures all of this out for you, which is just really, really helpful. Perfect. So just moving on to paid parental leave. I'm just going to cover a little bit of other types of parental leave as well. So parental leave and employment in New Zealand is prescribed in a separate piece of legislation, the Employment Relations Act or the Holidays Act. And what that is your parental leave and employment protection. Under this legislation, employees who are the primary carer may get up to 22 weeks paid from the government, and that rate has recently increased to $563. To be clear, that's nothing that the employer has to pay. That's up to the employee to organise that payment with IRD. From an employer's perspective, all you would usually do is confirm that that employee was employed with you, and what you would confirm what their kind of pay rates were and that sort of thing. The other thing that's recently changed is the keeping in touch days. So what this means is that while an employee is sort of on parental leave, they can do a couple of hours here and there, may work up to 52, and often that's quite helpful with handovers and that sort of thing, and their parental leave period is not broken. If an employee works more than 52 hours during that parental leave period, that parental leave period is then deemed to have ended. So they would need to come back to work. So under the law, the different types of parental leave they sort of have, you've got your primary carer leave, which is that I just mentioned, you're 22 weeks at the moment, and that's if you're the primary carer of the child. So either the mother, or if you're adopting a child, the primary care of that child, or if you're in some other type of de facto relationship, that person who is going to be the primary carer. Special leave is for when someone is pregnant or is going to be adopting a child or something like that. And what this is it's 10 days after you know that you are expecting a baby, that you can then take time off to go to things such as doctor's appointments or might be seeing a midwife, it might be organising things. That time, however, is unpaid. So even though the employer has an obligation to give those 10 days, it is unpaid time. Partner's leave, so that is if you are the partner of someone who is a primary carer of the baby. What you get is 2 weeks at the expected date of delivery. That time is also unpaid. So even though as an employer, again, you can't typically decline that partner's leave, there's no cost to the business. You've also got their extended leave, and what that basically is, and that's most commonly what new mothers do take, is they then extend that 22 weeks and they can take it up to 52 weeks. Still, all that time is unpaid. Really, the only obligation you have as the employer is to typically keep that role open. There are some special circumstances where you may not need to keep that role open, but it is a very, very high standard to meet. And I won't go into too much detail because I think in all of my working career I haven't found any role that meets that standard yet. Negotiated care leave as well is just the final example, and that basically just means that employers should consider all different types of parental leave, and can always negotiate different types of care leave based on, say you're the grandmother of a baby, but it's going to have quite a lot of involvement and all those sorts of things to factor in, and you'd obviously need to consider any requests in good faith here. The notice requirements if someone is going to request parental leave, so they must give it to you as the employer in writing at least 3 months before that expected date of delivery, or before the expected date that they're going to assume care of that child under the age of 6. The notice should outline what type of leave they're taking, so if it's parental leave, your primary carer, your partner's leave, the duration of the leave, when they want to start and finish, and if, for example, you are the partner of someone who is going on primary care leave and you're wanting to take that leave as well, you would indicate to those spousal details if you were going to share that. The medical requirements, you do need something confirming that expected date of delivery or confirming that, that care of a child. And then the letter as well for primary care of a child, that's sort of a statutory declaration that you get from that relevant authority. Perfect. So now just moving on to workplace disputes. So in my job, this is something that we see come up a lot. So with your workplace disputes, there are obviously different ways that you can sort of resolve these. Under the Employment Relations Act, in an employment agreement, it must outline the way that a workplace dispute is going to be resolved. And what typically it will say is that, if there is a workplace dispute, the employer and the employee may seek, sort of help from mediation services and that kind of thing. Obviously, prior to that, you've got your informal conflict resolution. So clearly the benefit of that is that it can happen really quick. So, you don't have to wait for external parties to be available. You don't have to pay for any external parties. It often means things haven't snowballed, they haven't escalated or anything like that. Typically, the employer would usually oversee the issue, or if you have a general manager or that type of position, you might then look for that person to sort of be that type of informal mediator. And then if a resolution is not possible, that may be the opportunity then for you to seek external mediation. It is, I would say never kind of jump the gun and just go straight to mediation. I think it's always better to try and resolve things in-house before you kind of look to those external options. In my experience as well, so employers have sort of prematurely got that third-party involvement that often sort of prompts the employee to get third-party involvement, and then things can kind of escalate pretty quickly. With mediation, it's a formal process, and it is free, however, and it's provided for by the Ministry of Business, Innovation and Employment. They have offices all around New Zealand, and what they have is a group of mediators, and you would sit in front of that mediator, and both parties basically get an opportunity to outline their dispute. Because it is a free service and it is overseen by the Ministry of Innovation and Employment, Business Innovation and Employment, they basically set the date and time, so sometimes it can be a couple of months before you're able to sit in front of a mediator. Obviously, if you still have the employee at work during this time, it can be a bit unpleasant if there's sort of that dispute hanging over everyone's head. The mediator doesn't necessarily give an opinion. They're not like a judge or anything like that. What they're sort of there to do is to act as that neutral party. They basically let both parties kind of say their side, and then typically speaking, both parties would go off into separate rooms, and they then are given that opportunity to kind of work with the mediator to try and get to that resolution. Successful mediation may end in sort of a positive, workable employment relationship moving forward, or alternatively, unfortunately what happens more likely is there'll be some sort of record of settlement or a written agreement with how that relationship is going to work, and usually that is that relationship ending and the terms of that relationship ending. If there are, for example, terms when that relationship is going to continue, This would be outlined in that record of settlement as well. So it might be, what both parties agree to do or what is needed to continue that relationship. And then that record of settlement becomes a legally binding document, and the mediator signs that basically to confirm, that that is in place. So workplace disputes, personal grievances. So I'm not sure if anyone's had an experience with personal grievances, but what basically in New Zealand, the option there for an employer who wants to make employee who wants to make a claim against their employer is they would raise a personal grievance. It is free to do, and it's very easy to do because all you need to do is notify or communicate the grievance in writing. So I'm sure you've heard it's become kind of colloquially referred to as a PG, and a lot of employers are like, oh, we can't do that, we're going to risk a PG, and this is what they're referring to as a personal grievance. So with the grievances, there's two different types. So one is unjustified disadvantage, and what that basically means is that the employee has somehow been disadvantaged in their employment and they are formally raising a grievance about that disadvantage. Common things that disadvantage includes might be, say, a pay decrease. It might be a change in job without consultation. It might be a reduction of hours without consultation. All these sorts of things where an employee comes to work and somehow their employment has been changed to their disadvantage and they are formally raising a grievance about that. If an unjustified disadvantage grievance is raised, often the employment relationship is still there. However, it does make for pretty awkward times, and usually it will end at some stage after that grievance has been raised. The most common type of grievance that I see in my job is an unjustified dismissal grievance. So this is where someone has been terminated from their employment and they feel that that termination wasn't justified. It's either not justified on a procedural basis or on a reason basis. So if someone was, say, terminated and there was a really good process followed, but it was just for being late one time, that reason would likely not be genuine enough to justify that dismissal. Alternatively, if someone steals something or something like that and the employer just goes, you're fired, get out, that could still be an unjustified dismissal but based on procedural grounds. So you've probably got that genuine reason there, but that fair and reasonable process wasn't followed. So that sort of idea that you can just dismiss an employee on the spot, say things like you're fired, get out, it doesn't exist in New Zealand. The law is very, very clear that a process needs to be followed if you are considering terminating someone's employment, really similar to like a criminal kind of court where you might have someone, you see the person, red-handed with the gun, they still get that trial and they're still entitled to a defence. Very, very similar with employment. You could see someone stealing money from the till, they're still entitled to be able to provide a response to those issues prior to any decisions being made. So a personal grievance, it must be raised within 90 days from the date that the alleged action happened, and it does need to be raised in writing as well. So an employee can't retrospectively come back and say, oh, I told someone verbally I was going to raise a grievance or anything like that, because there's no evidence that that happened. After 90 days, an employee cannot raise a grievance unless the employer agrees, which I don't think they usually would, or unless there has been some sort of information that wasn't available within that 90 days to give the employee grounds for a grievance. Basically what happens when there is a grievance raised is, you would then have that obligation to consult with the employee to try and resolve that grievance. That's typically where that formal mediation services come in. Otherwise, if it doesn't get resolved at that informal stage, what the employee then may do is file with our Employment Relations Authority. That's the old employment tribunal, and then that turns into a more formal sort of dispute there, where it's kind of then becomes like authority mandated. So things stop being voluntary and you may get called to a hearing or those kinds of things. So if possible, we always try and avoid that because it's very costly and very timely. A common example we do see for a grievance is a constructive dismissal. So this falls into that unjustified dismissal category, but it's basically the employee won't necessarily have been fired, but they feel that they had no other choice but to resign. So commonly this could be, an employer might say, look, if you don't resign right now, I'm going to fire you. So that's a really common example of a constructive dismissal. Otherwise, unreasonable pressure may be placed on the employee to resign, or they may have sort of poor working conditions or poor treatment by the employer. might not feel safe at work, might be feeling they're being bullied, harassed, whatever it might be, where they feel they have no other option but to resign there. Quite often, interestingly, these grievances are paired with an unjustified disadvantage. So for an example, if an employer said, I'm dropping your pay by $20 an hour, and the employee says, well, I can't work for that, I'm going to resign, they'll basically then pair the two grievances together. So see how much kind of ammunition they can use. So we just want to avoid all of this by just making sure that fair and reasonable processes are followed with your employees. Next thing there is redundancy complaints. So I often, when I'm talking to clients, a really common thing that sort of says, when I'm like, look, we can't just fire that person, we need to follow a process. A really common thing that seems to come up is they say, well, we'll just make them redundant. Unfortunately, in New Zealand, again, that's definitely not the easy option. And if anything, I would say it's actually a worse option because redundancy is seen as an employee's employment ending through no fault of their own. Therefore, the employee is actually held to a higher standard than if it had been something the employee had done and was then terminated for that. So similar to that kind of termination category, the Employment Relations Act basically says that if there is a redundancy and it's a genuine reason, then that's fine. Employees' role may be considered surplus to the business, but again, a fair and reasonable process does need to be followed. And it's just really important to always keep in your mind, redundancy is about a role, it's not about people. So if you have someone who's a poor performer, making them redundant is not the solution to the problem, because that person could then challenge the genuineness of that redundancy. Obviously, if you have, say, 10 roles available and you're going to make 2 of them redundant, you're not going to, when you do that selection criteria, you're not going to keep on the people that you feel are the worst performers. But again, you need to make sure it's genuine. And then once you've confirmed the genuineness of that redundancy, that the employees you are keeping on, there's been a fair selection process followed. So what a fair and reasonable process sort of looks like in a nutshell in the employment law? The employee needs to be given warning of that redundancy. So usually that would be in a face-to-face meeting where you sort of say, like, look, because of X, Y, Z reasons, unfortunately, we're considering making your role redundant, and here's a proposal about that redundancy. And what that proposal should usually include is any information the employees may want to consider that they could kind of provide feedback to about why their role is no longer required in that business. After they've had a reasonable time to sort of look at that proposal, look at any evidence of that proposal, you then have an obligation to consult with the employees, which is that next box there, consultation. What that basically is, again, it's a really formal kind of word for a meeting, and you just sort of meet with the employee and you say, look, this is what's happened. Do you have any feedback about this proposal? Is there anything you think we should know? Is there anything else we haven't considered? So really giving the employee the opportunity to provide any feedback in relation to their employment and a business decision that may affect their employment. In this consultation time, it's good to note as well that a support person is allowed, so the employee is entitled throughout this process to obviously seek their own support and advice. You've got then their redeployment. So in the business, if you are making someone's role redundant, you would need to consider all other areas that the employee could possibly do work in the business. If a new role has been created, what you would sort of look at is, does the employee have the skills for that role? And if they don't have the skills, could they reasonably be trained in that role? So you don't have to go and pay for them to do a degree or anything like that. But if it's, say, going from an accounts admin assistant to an accounts receivable assistant where no formal qualification is needed, you would likely be expected to train the employee to be able to do that position. If it was accounts admin and now you're going to get a chartered accountant, you're not expected to put that employee through, a commerce degree or, get their CA or anything like that. This redundancy, basically the same category for personal grievances for unjustified dismissal I mentioned before applies, where once that redundancy is confirmed, the employee then has 90 days to raise a possible grievance as a result of that redundancy. And it's important to note here, if an employee does raise a grievance with the redundancy and it does go to the authority, basically all that business information that you used to make that decision for that redundancy becomes discoverable. So what they can do is they can have a look through it to really ensure that the genuineness of that redundancy was there, and then also then that a fair and reasonable process was followed after that. Okay, now we're just going to go on to discrimination, something that we have seen in the last probably 2 years, we've seen a lot more of these types of claims arise. So discriminatory type practices, obviously they have a negative impact on a business anyway, regardless of the legal ramifications, but they can be bad for staff morale, bad for staff commitment, not high performance, not good productivity. So it's just really good in your workplace to ensure that you constantly have that sort of objective, unbiased approach with your workforce. So discrimination can obviously occur as early as the interviewing and recruitment process, and we all have what's called an unconscious bias, and what we want to do as much as possible is try and remove that when we are hiring a workforce. I think an answer there would be aware of potential discrimination. So once you have that candidate and that person then becomes an employee, just ensure that everyone is treated fairly. So any conditions and benefits, we want to make sure that they're fairly kind of given to employees. You're not only giving conditions and benefits to, males or that sort of thing, or younger workers or older workers or whatever. Promotion and selection process as well. And then that same thing, just briefly, from redundancy, if we are, choosing the successful candidates who may stay within the business after a redundancy, we want to ensure that's based on like a fair selection process. So the New Zealand legislation, particularly the Human Rights Act, protects everyone and employees for discrimination against your standard things like your age, race, your ethnic group, your religion, sex or sexual orientation, pregnant women, or people that may need to have flexible working because of breastfeeding, same as your family and care responsibilities, and then the physical or mental disabilities. Really important as well to note that in New Zealand, you've got kind of a three-pronged approach from a legal perspective with discrimination. So these categories that I just mentioned are outlined in the Human Rights Act, but discrimination is also unlawful in the Employment Relations Act, and it's also a protected category in the Health and Safety at Work Act. So you're kind of coming at from 3 different areas that can lead to issues with discrimination from a legal perspective. So discrimination, it's not always something that we sort of know is happening. So direct discrimination is obviously that really overt kind of one employee is being treated less favourably, because of a particular gender. You might have, everyone in management is a male, therefore they're only promoting males into that higher management position, those sorts of things. Indirect discrimination could be something that is less obvious, so imposing a requirement that unnecessarily disadvantages a certain group. So you've got banning beards, for example, which could affect particularly, religious employees, where that may be something that, because of their religion, that they might need. Otherwise, as well, things, for example, if you have working mothers, women who are breastfeeding, if you're making sure that it's an 8 to 5 work day and that person isn't allowed to leave the workforce, indirectly you're actually discriminating against that group because they would be unable to perform those duties. So you just need to consider about what you could factor in. I think the big thing with managing discrimination, if an employee raises concerns about discrimination, don't just sit on it. A formal investigation must be commenced. What that formal investigation can look like is it's going to depend on the complaint, but really you would kind of meet with the person who had had the alleged discrimination, say that they were the person who was discriminating, and you might then meet with the person who was complaining about that discrimination as well, get as much information as possible as you can, and then sort of determine based on that investigation whether those allegations were substantiated. If those allegations are substantiated, disciplinary action or some sort of formal action or intervention should be taken against the relevant individual. So this could include, if it is discrimination, which is in a very direct and overt way, that could be dismissal, depending on what sort of things were said. Otherwise, it might be a formal warning. It could be something that's not formal. It might just be about training. It doesn't necessarily have to be disciplinary action. We don't want to assume discrimination has a malicious intent, but there should be some sort of action taken if those allegations are substantiated there. And then following this outcome should then be communicated to the person that raised the issues in the first place. What we want to make sure is that they know that the issues have been taken seriously, the relevant parties have been dealt with in line with company policies. You don't necessarily have to say exactly what the outcome was, because you do need to protect the other person's confidentiality too. But I think it's just really important to reinforce, that the investigation has occurred and that you've sort of investigated it in line with the company processes and a relevant outcome has been determined. Great, so now just on to employee performance. So poor performance is something, unfortunately, that comes up a lot as well in my job. It can be really difficult to manage, and I think it's just about making sure, we jump on it quickly so that if there are any issues, we can sort of start that process rather than waiting until sort of people are at breaking point. The first thing there, poor performance is often unintentional. That's something that I hear a lot in my job where, people are, oh, I'm really unhappy with this employee, they're not performing well, and, I hate the way they do this, and whatever it might be. And I say, great, what did they say when you told them? And they're like, oh, I haven't told them yet. So straight away, we shouldn't assume that poor performance is a conscious decision that someone is making. In the first instance, if you're not happy with someone, the way someone's doing something, have that discussion with them. Don't let it get to the stage, don't let it assume that they know that they're not performing well and therefore they know that they need to improve. So identify issues early with performance reviews. I think having annual performance appraisals, regardless of whether someone's a poor performer or a good performer, is best practice anyway. What we want to have in those appraisals is it's a great opportunity for you to sort of outline to the employee where they're kind of at with their performance. Also a really good opportunity for the employee to kind of give an indication of where they are as well. These can be informal or as informal or formal as you like. In regards to that, if you were going to have some sort of a formal meeting, which may lead to possibly a formal performance management plan or the dismissal of an employee after that process, really important that you make those meetings formal and that you tell the employee they can bring a support person, because that's just going to make sure that if we do end up leading to termination, if that employee doesn't improve, we've followed that fair and reasonable process along the way. So examples of poor performance, you've got sort of someone just isn't able to do their job, they're failing to meet those required standards, and there might be, say, repeated errors in work and that sort of thing. Poor performance typically isn't things like, say, swearing at a customer or, kind of being late or going home early when they aren't authorised to. It usually is related to their job and the ability to do the job. Sometimes it can be a grey area, so a common one like, repeated errors in work. We could possibly look at framing that as something like negligence in regards to their duties, so frame it as misconduct that way and do a disciplinary process. However, again, you just want to make sure that, the employer has provided support to the employee to try and improve. To dismiss someone for poor performance, it is a long process. It definitely is something, if ever I'm entering kind of a performance management process with clients that I'm dealing with, is sort of make sure that they understand along the way, look, this is something that you're going to need to be patient, it's going to be a lot of meetings, but we will get there one way or another. So what we typically find is through a performance management process, the employee either improves, which is the goal. Pretty much people, I would say 80% of the time will end up resigning, because being monitored throughout performance is just something human nature they don't like. As a side note, if someone does resign during a performance management process and you can demonstrate that it has been a fair process, that employee, if they did raise a constructive dismissal claim or said they were forced out or anything, we would be able to shut that down very quickly. And the other option is that then the employee may be terminated through an accumulation of warnings throughout that performance management plan. So what the sort of steps are is you would usually formally meet with the employee, outline those areas of underperformance and why you're unhappy with their performance. We want really clear examples as well. They need to be as specific as possible. It's not good enough just to say, I'm not happy with your performance. You sort of need to say why, what areas in particular are you not happy with, and then give that employee an opportunity to just kind of give if there is any justification to those downfalls. Often if someone has been a great performer over 5 years and then suddenly they drop the ball, it might be that there's something going on personally or outside of work, And it may not be that a formal performance management plan is necessary. They may just need a little bit of emotional support or something like that. Following that formal meeting, an outcome then may be to set a performance improvement plan, which is number 3 there. What that performance improvement plan outlines is typically what those goals are for the employee in relation to their job, what the kind of target is, and then the time frame that those goals are going to be monitored, and then whether they met those goals. So goals are going to be really specific based on the particular role. Obviously, if something like sales, really easy to monitor because you've got your targets and your KPIs. If you have sort of an administrative role, the goal might be that they need to finish, all their work within the day, and there needs to be a, no errors, all that sort of thing. And then you just do a time frame for monitoring that performance. If it's a, it's kind of a bit of a how long piece of string, so how long is the performance being monitored? Basically, the employee needs to be given an opportunity to demonstrate they can perform and an opportunity to improve. So I'd be saying a kind of 2-week period is pretty typical for that first monitoring. So what happens if the employee doesn't improve over that, say, 2-week or initial monitoring period? What you would then look to do if they haven't improved is issue a formal warning in relation to their performance. Following that formal warning, that performance improvement plan would then continue. If after that second monitoring period it still hadn't improved, they may be issued, say, another warning or a final warning. And finally, after that further monitoring period, their employment may be terminated. If you followed that fair and reasonable process along the way, that dismissal would be considered justified. It is important to make sure that the employee, unrealistic targets aren't being set or anything like that. They've been given a genuine opportunity to actually improve. If there is any reasonable support that's required, the business should definitely provide that as well. Again, you're not expected to pay for a whole lot of external training or anything like that, but I think it's good to know that, not everyone picks things up as quickly as others, and all employees are different, so you can't sort of assume that what's worked for one person is going to work for everyone. So just want to demonstrate, that you have tried to get the employee's conduct to improve. Really good way, to put that onus back on the employee during this process and, kind of outline, what do you need from us? What can we do to help you improve? Often, I know some employees respond really well to having sort of a buddying system, like they may want to buddy with another employee who works really well. Other employees may not like that approach. So it's just really good to sort of consider that, asking the employee what they feel would be a good way to get their standard to where we want. Perfect. So these are the sorts of areas that will mean that the employment will likely, that termination will likely not result in a grievance. So you must act in good faith. The outcomes for the performance management plan should not be predetermined. So you shouldn't go in thinking, yep, I'm just ticking all the boxes to get rid of this employee. You really want to genuinely try and get that person to improve. We don't want to set the employee up to fail. Have to act and have that reason as well. Fair and reasonable process we've talked about. Try and remain open-minded, and document is the key. We want basically evidence of everything. If you've had meetings, if you've had discussions, if you've provided training, if you've provided support, we want documents of everything. This process must comply with the requirements set out in the Employment Relations Act, very similar to any other termination processes like we talked about, redundancy, your other dismissals there as well. With that in mind, just a bit of a summary around what's considered a justified reason for considering termination versus what would be an unjustified reason. What the Employment Relations Act outlines is a test of justification for whether someone's dismissal was all right. And what that basically says is that, a dismissal in all circumstances must have been a justified option. So what would a reasonable employer have done in these circumstances? So performance issues definitely can be justified if we've followed that fair and reasonable process. Repeated misconduct, so that may be things like, someone's constantly showing up late, they're constantly leaving early without authorization. Little instances that in the first instance may not be considered serious enough for that instant dismissal, but that with that accumulation of warnings definitely could lead to a justified dismissal. Serious misconduct, so that's again like areas that are a lot more serious, like theft, your physical violence, abuse, overt discrimination, things that may lead to an instant dismissal. And again, like I kind of said, instant dismissal does not mean, you're fired, get out, see you never again. It is a dismissal without notice following that fair and reasonable process. Redundancy, if it's a genuine redundancy, and incapacity. So that would be if someone is medically unable to perform their duties anymore. Unjustified reasons for dismissal. So you've got obviously personal reasons, so just I hate that person, we have a personality clash. Prejudice, so that's your discrimination. Wanting replacement, often, I know this one can come up if someone's, say, been hired on a fixed term basis to replace someone and then that person comes back from leave. And you might think, oh, damn it, this person's doing way better. Unfortunately, we can't get rid of that other person just because you want to replace them. And then once-off misconduct. So like I kind of mentioned before, if someone showed up late once, that would not be, even though that may be considered misconduct, it would likely not be enough to be a justified dismissal there. So finally, the last section we're going to go on to is health and safety at work, everyone's favourite, I'm sure. But obviously, in a couple of years ago, the New Zealand Health and Safety changed the legislation to be the Health and Safety at Work Act. And what this basically did is it increased an employer or a PCBU's obligations on the safety of all their workers during business. Previously, it was just about an employee, and that kind of board level or that director level couldn't be held personally accountable. Now it's sort of changed to be it's actually everyone to do with your work that you need to keep safe, and now directors or officers or PCBUs can be held accountable for any health and safety breaches. So effective health and safety policies can increase productivity if everyone's feeling safe, if you've got safe ways of working, people aren't then mucking around with trying to find that. And reduced insurance premiums if you're keeping people safe, fewer absences, better employee retention, reduced costs of training and replacement, and obviously can protect businesses from bad publicity. I'm sure we'll all see in the media and in the news sort of examples or news articles of businesses that haven't kept a safe workplace and therefore have been penalised for that. So the health and safety typically falls on those directors and board members. If you have a big business, there may also be another level in there, which is called an officer level. That may be, possibly health and safety advisors, it might be HR advisors, anyone who basically has an influencing capacity over that director or board level. There can be harsh penalties, financial and personal, for non-compliance. The penalties that we're seeing are very high, which sort of indicates that WorkSafe have come down pretty heavy-handed with this sort of thing. And obviously the personal penalties are even worse, and that's for things like, you could go to prison, for example, if you put your workers in danger and you're acting in a reckless manner. Employers need to ensure that as far as reasonably practicable, that the health and safety of their workers, any other workers, influencer children, or any other people that the business may come into contact with during their practice or during the work of the business, that health and safety is protected. So as far as reasonably practicable, again, sometimes it's a bit like how long's a piece of string. It doesn't mean that you need to go and spend thousands and thousands and thousands on safe work systems or anything like that. It's just saying in your business, the line of work you're doing, what is reasonable and what is practical in these circumstances to keep people safe. So compliance, so the primary duty of care, and this is basically I would encourage everyone, if you are at that director level or a sole trader, to have a statement like this outlining that you are committed to this particular area. What it basically, the Act says that you must do this, so you cannot contract out of this. If you are starting business, you are bound to this, whether you're running a construction site or a nail salon or a childcare centre, the Act is the same. It's more just those risks associated with those different types of work are going to change. You must provide and maintain a work environment. That obviously those risks are minimised and controlled. Provide and maintain safe plants and structures. You need to provide safe systems of work, ensuring the safe use and handling of different plants and substances. Provide adequate facilities, and then monitor the health of workers and those conditions. So that's most relevant if you do have someone in a particularly physically strenuous job, or it might be a job that someone's exposed to, say, dust or that sort of thing. You need to monitor that person's health to ensure that even though that immediate risk may not be there, there's no kind of long-term adverse effects on that worker for the type of work they're doing. fundamental elements to sort of managing your health and safety. You want to identify and assess those risks and then eliminate or minimize those risks, put controls in place, and then review for continuous improvement. So obviously, unfortunately, in the world, we can't prevent all accidents from happening. What you want to be able to identify if there is an accident in the workplace, that you had identified that risk. Within your power, you had either tried to eliminate that risk or minimize that risk from a relevant control measure. So most, really common one that everyone sees is, say, working with heavy machinery. If your business is sort of revolved around that particular task, you're not going to be able to eliminate it completely. So, you might put in measures like having guards around that machinery, or you might require all employees to wear personal protective equipment when operating that machinery. You might ensure that all employees have been trained formally in that piece of machinery. So it's just about making sure that you're putting those control measures in place. When you say reviewing for continuous improvement, that just as well, again, it doesn't have to be on a weekly basis or anything like that. It's just sort of looking at, making sure those controls are still relevant. If there's an incident or something involving that particular task, you may want to do an overall review of what types of risks you tried to control there, and it may be that something needs to change. So that is basically all from me. I've got some great questions here, so we're going to kind of have a talk through some of those. So the first one we have there, so someone's commented and said casual employees shouldn't be rostered and should be days as that's not casual. So what sort of happens there is you can still have a casual employee who you might not be regularly on the roster. You might, for example, call them in at the start of the week and say, hey, we need you to work on Thursday because we know someone's going to be away on the Thursday, so they're still put on that roster there. That doesn't necessarily make them a permanent employee as long as there's no regular work pattern and as long as they're regularly not on that roster there. Just got a question there about maternity leave. So with reference to maternity leave, so after someone works full-time and if they've come back in 12 months' time on 2 days a week, what annual leave do they accrue? So basically when someone comes back from maternity leave or parental leave, and if they do then have a flexible work arrangement where their hours of work have changed, so we want to obviously formalise that in a variation to their contract, and then they would begin to accrue annual leave on that new basis. So when someone comes back from parental leave or maternity leave, any annual leave that previously accrued is paid at a lower rate, and then you've got people there that would then accrue annual leave on that 2-day-a-week basis. She wouldn't get her previous entitlement of 5 days once she returns. Perfect, and just got there as well, what period do you calculate ordinary weekly pay if it's irregular hours, and how many weeks do you go back? So if someone's working irregular hours, I would be saying that their annual leave should be calculated on an average weekly earning basis. If you're looking at ordinary weekly pay, I would typically look at a previous 4-week period. It's just more you would look at what is the employee expecting to be paid for that week. If it's irregular, it's hard to determine, which is where the average comes in really, really nice and handy. If it's something where, they've say just got a pay rise a couple of weeks earlier, they would then likely be expecting that pay for that period of annual leave. I think a 4-week period is a good kind of time frame to have in mind to go back if you're looking at ordinary weekly pay. Average weekly earnings, you would go back over the previous 52 weeks if the person has been there that long. If they haven't, just do the previous weeks from however long they've been there. I've just got another question there. So they're keeping in touch hours with parental leave, and I'll see if I can bring up that slide again. So the keeping in touch hours of the 52 hours, it's just over that paid parental leave period. So it's not over the whole year, it's just 52 hours in that 22-week period. So if they go over that 52 hours in 22 weeks, that period of parental leave will have deemed to be finished. Well, we've got a good one there about annual leave with parental leave. Oh gosh, all coming through. Can you explain about the 4 weeks accrued while on maternity leave? So yes, that's a very, very good question, and that one comes up a lot when someone does come back from parental leave. So during a period of parental leave, someone does still accrue annual leave. So if they've gone for a year, in theory, they will have accrued a 4-week entitlement, which is what that question kind of asks, what then happens to that 4-week entitlement. So what happens when that person returns from annual leave? is that any leave they have accrued while they have been on parental leave is only paid at their average weekly earnings. So this is the one exception to that higher of average weekly earnings or ordinary weekly pay rule. Annual leave is only paid at the average weekly earnings if they accrued it while they were on parental leave. So what then happens is if someone's been away for a year and then they say take annual leave a month after coming back, the annual leave is going to be paid at a very low rate, because in theory that person won't have had any earnings over that year, or if they had any earnings it won't be very high. So sometimes employees can be sort of caught off guard when they come back from maternity leave and then all of a sudden they take annual leave and it's paid not very high. So that's sort of why, and that's completely legal as long as it's only annual leave that has been accrued while they're away on parental leave there. So can you discriminate someone based on smoking? Oh, I love this one. It comes up a lot and I get a lot about vaping as well. So essentially, it's going to really depend on the industry. What you can have is you can have a smoke-free business and a smoke-free sort of premises and that sort of thing. So you can tell someone, if they were to smoke, they weren't able to do it anywhere associated with your business. Also, depending on your industry, for example, if you were in, say, the beauty industry or, health industry or relaxation industry, you could sort of have a policy or a code of conduct that was like, smoking is not in line with our sort of philosophy here. If someone was smoking outside of work and there was absolutely no impact on the way it meant that they were going to perform their duties, possibly couldn't discriminate based on that basis, but you can definitely ensure that your workplace and everything they're doing at work, that smoking isn't involved in that if that's particularly relevant. So I've just got there as well, how do you allow someone to breastfeed if they have to leave to do it? So again, if it's going to be completely impractical, what the employer basically just has to do is consider any sorts of requests in good faith. So if someone was going to breastfeed and there was absolutely nowhere at the workplace they could do it, they were going to need to leave work to do it, there was no facility that the work could possibly provide for that person to breastfeed, you could possibly look at making their hours a bit longer. So could they say finish half an hour later and pop out during the day to breastfeed? Is there a facility down the road they could use? You just sort of look at all possible options that you could do to sort of facilitate that. I mean, if there was absolutely nothing you could do, you would need to be able to outline those reasons as to why there was nothing you could do, and then you could possibly look to decline that request from that perspective. Perfect. So just there, one about misconduct. So reasonable amount of written verbal warnings that can be given for misconduct. This is always a really good one as well. So I'm very passionate about this stuff. So with that, there's no, no kind of rule of thumb prescribed in the legislation as to, someone has to receive a verbal and then a written or anything like that. I would always outline a policy, that you should have a policy around it, just to kind of give some guidance and to give you some leverage if you ever were going to look to terminate for an accumulation of warnings. But a rule of thumb for the same type of conduct, so let's use lateness as an example. If someone was constantly late, I would say they should receive some sort of a verbal warning or an expectation setting in the first instance, possibly then a written warning, final warning, termination. So usually you'd say something like, getting a formal written warning, then your formal final warning, and then it could lead to the termination of your employment. With those though, it is always going to default to back to, what's reasonable. If the termination warning was going to be they were 2 minutes late, I would say that's possibly not reasonable. So always sort of keep in mind, there's no kind of set standard, but yeah, that's sort of typically what we see. Definitely encourage you to put something like that in a policy. Instances of misconduct, here's the process you would follow, verbal, written, final, termination, or something like that. Perfect. So just on there about annual leave too, you have to pay out any annual leave at the end of each 12-month period, or can it accrue? So under the law, annual leave must accrue. So you can pay out 1 week per year. So this would be paying an employee a week of their annual leave while they're actually still at work and not taking their leave. But that's the only amount you're allowed to pay out per year, is just 1 week. Otherwise, annual leave just accrues year to year. Once annual leave has become entitled, obviously those annual leave balances can become quite costly, but what you can actually then do is direct someone to take that leave. So you can give them 14 days notice under the legislation and tell them that they need to then go on annual leave. for however much their balance might be. I understand that kind of accruals can get very, very costly, and all of a sudden the liability is quite big. So definitely a good opportunity to manage that leave. So just got there as well. What if you've become smoke-free after you've employed a smoker? Oh, with this one, it's, I think it would just be, again, making sure employees are consulted with those sorts of decisions. If you've got a workforce of 20 and 19 of them are in support of your smoke-free workforce and one person doesn't want it, I would be saying, that's unfortunate for that one person. Otherwise, you'd look at, okay, well, what does smoke-free being, smoke-free for that business look like, and how is that possibly going to disadvantage that employee? So if, say, previously they used to just pop outside and smoke, is there somewhere, 10 metres down the road they can then go? Is it just going to be maybe they need to take off their uniform so no one in your uniform is smoking? It really is going to be that smoke-free workforce. What does that look like? And with that in mind, how could that possibly disadvantage that person? Again, it would just be about sort of consulting, so kind of saying, hey, here's where the business is sort of going. We want to get everyone's feedback before we make any decisions. As long as you can show you've considered that feedback, you are then in a position to look at making that decision there. Perfect. So we've got there as well a little bit about contractors, which is always a very good one as well. So contractors with a uniform. So that one, it's not the be-all and end-all. It's not saying that someone who wears a uniform is not going to be an independent contractor. However, wearing a uniform and being integrated in the business is quite indicative of employment. So it's always good to sort of consider and take a step back. If you do have an independent contractor that's wearing a uniform, look at other aspects of that relationship. Are they invoicing for work? Are they GST registered? Are they a limited liability company? Do they have quite a lot of flexibility over the work they do? If all those are yes, I think you're okay to keep them as a contractor, but it can be a good opportunity to sort of look at what's kind of going on there. Probably only got time for one more question. So where it says there, if your employees get more than 4 weeks leave, can you pay out more than 1 week? So that will depend on a policy. So under the law, all it says is that someone's entitled to 4 weeks leave and you can pay out a maximum of 1 week of that annual leave per year. If you have a policy where someone, say, is entitled to 5 weeks leave or something like that, I'd look at the wording of it. If it's referred to as annual leave, I would say that 1 week paid out still stands as per the legislation. If it was, say, an additional discretionary week's leave, or, you had quite a lot of options about, what sort of things that person could do with that leave, then I think you could probably have a bit more flexibility there as to whether you wanted to pay out more than 1 week, or whether that 1 week was considered annual leave, or if you wanted to put it in a different type of category. That's awesome. I'm sorry I didn't get to everyone's questions there. Thank you so much for attending, and anyone who, if we didn't get to your questions, we're going to email, we'll be reaching out by email anyway, so we'll be able to follow up with all that questions there, and would love to meet to discuss any of those ones we didn't get to, and obviously welcome to meet as well and do a free workplace check too. Thank you so much everyone, really, really appreciate your attendance. Thanks.